Joining me now is a lawyer, Olufemi Aino. Thank you for joining us on TVC Breakfast. Good morning.
Thank you. Good morning.
Now, let's take a critical look at the handling of this case by the federal government. As a lawyer, what do you make of the whole process so far, taking into cognizance the judgment of last week?
Yes, let's just take it from there, because a lot has happened in the past,
Absolutely.
which I think the federal government have their own share of the blame, because they made a mess of the case. But let's just take it from last week. And now we have a conviction, because 2 people pleaded guilty.
Absolutely.
And it is quite obvious now that there has been a lot of underhand dealings regarding this contract right from the onset. The only thing I'm going to say right from now is that there's going to be a hearing on the 26th, which is on Thursday.
Yes. And
that hearing is actually listed for what is called an attachment, because what P&ID have done is that they've managed to identify Nigeria assets, and they are coming to court to say, look, we have this judgment, can you make an attachment order so that we can see some of these assets? But there has been a lot of development because of the conviction in Nigeria, the order of the court, and we must commend the Attorney General, because he's now taking the bull by the horn to make sure that, look, we are going to fight this out. The investigation is still ongoing, and he said, look, a lot of people are still going to be charged. So on the 26th, Nigeria will have to make an application that this award should be set aside because of the fraud, and that common law fraud vitiates everything. And there will be argument here and there. What is admissible is the certificate of conviction that, look, some people have been convicted. But notwithstanding, it may well be the matter is not going to be concluded on the 26th. It's still going to be adjourned for the application to be set aside. So
invariably, how much impact is this judgment that was had on Thursday going to have on the case? Yes,
I'm very grateful you asked me that question. Even if you look, one of the basis in which you can challenge an arbitral award is if you look at the Arbitration Act of 1996, which is the one that is applicable here. Yeah. If there is a serious irregularity under Section 68, just give me a second, I know we are not going to be here till Christmas. The award being obtained, one of the grounds is that the award being obtained by fraud, or the award, or the way in which it was procured being contrary to public policy. Is it not contrary to public policy for you to be giving bribes so that people award you contract? So those are the grounds, and that is what Nigeria is hanging on, that, look, this contract is contrary to public policy, there are some element of fraud involved. So what they need to do now, since they have this conviction, go with the certificate of conviction, get a witness statement, and you need to try as much as possible and get one of these people to turn into either a whistleblower or whatever, so that they can tell you how money has exchanged hand in this. And there's still another issue. Even the expert used in this case, who is in Nigeria, it has now transpired that either the man was paid about $50,000 allegedly, but there is an argument that, look, it's not supposed, he shouldn't have even given that opinion, being a former this and that, and the law doesn't allow that. So when you look at all this in the round, it may well be the judge will probably say, look, we are going to set this aside, or the matter should be
but there was a response from P&ID, and they described that trial and conviction by the Federal High Court as a sham and entirely illegitimate.
Well, what do you expect? If you are expecting 9.6 million from somebody, definitely billions. My apologies. So what do you expect? That's what they're going to say. Whether it is a sham or not, the court will tell you, look, we are not here to criticize the Nigerian judicial system. And there's one thing which is very vital. I appreciate, it's quite curious, the way the federal government of Nigeria managed to get these people convicted with a speed of light, because they were shot to court on the 17th. By the 19th, they've pleaded guilty and they've been convicted. You see, once you plead guilty, that is a matter for you. The only thing Nigeria is going to argue is that, look, they were represented by lawyers. We show them the evidence, and also at the end of the day, having received legal advice, they pleaded guilty. Right. What is the sham there? That has got nothing to do with
Interesting.
And then it goes on.
We wait to see what happens on the 26th.
Now, let me read out a statement by the Attorney General of the Federation, Malami, who are on their way to, in fact, who went to the UK with others. Now, he said, arising from the proof of evidence that we have in support of the charges that were filed by the EFCC, there is evidence that money changed hands between the international partners and officials of the Federal Ministry of Petroleum Resources, influencing things that had to do with the agreement, influencing the formation of the agreement, influencing what clauses should go into the agreement, influencing the officials to ensure the bypass of the vetting by the Federal Ministry of Justice, influencing the bypass of the presentation of the agreement before the Federal Executive Council. Just how big a case are we looking at? Yeah,
it's a busload. But the issue here is this. Even if you read that Attorney General statement very well, it's even contrary to the Bribery Act in the UK, because you must not give bribe in order to secure a contract. And you cannot even argue under the Bribery Act that, look, that is the custom in that country. The law doesn't allow that. And the problem we have here is this. Number one, on the 26th, they will go to court. Nigeria is going to lay all the cards on the table that, look, we don't know this. Evidence has now come to light that there has been a lot of underhand dealings. And because of that, they are going to raise an objection to an attachment of Nigeria assets. But they have a hurdle to cross because they've been participating in proceedings, they've been getting across the PD and I, trying to negotiate and what have you. So the hurdle is this. Under Section 73 of the Arbitration Act, Nigeria will argue that, look, there's been a lot of serious irregularity about this, but they have one hurdle, and that hurdle is this. There has been any other irregularity affecting the tribunal or the proceedings. But he may not raise that objection later before the tribunal or the court unless it shows that at the time he took part or continued to take part in the proceeding, he did not know and could not, with reasonable diligence, have discovered the grounds for the objection. Okay. So there will be a question from one of the judges that, look, how come all this is just coming to light? And, you know, when it comes to the issue of fraud, sometimes it may not be transparent. It might take time because maybe the people, once they are still in power, they will be hiding things and you won't know. And evidence will come to light. So that will be argument from Nigeria's side that, look, it is now we realize that this was not even transparent enough and what have you. So there will be arguments here and there. But the Nigerian main point is that they need to try as much as possible to set this aside.
What options, what are the greatest options left on the hands of Nigeria right now when it comes to strategically looking for a way to win this case?
You see, the case strategy seems to be going on the right direction for now. And I must commend the Attorney General. You know, the last time I was here, I was a bit critical. But now I think they are getting the best legal advice and they are trying to put what is called a cast iron case against all these people. Now, the other strategy is this. Who signed that agreement? Who was the minister at that time? Unfortunately, the man is no longer here with us. But leaving that aside, he was not buried with his telephone. So you need to get one of the telephone provider and get so that they give you what is called cell phone analysis. If I text you and you text me, you delete the text. It doesn't mean the text is not in your mobile. When I do a cell phone analysis, it will show me all the text. And then we need to see whether there has been one form of underhand communication between this dead minister and the gladiators behind the P&ID. So that will help you. So Nigeria needs to look at that. And at the same time, they need to turn one of these people to turncoat or a whistleblower who will tell them, look, this is what happened. Even if we have to give them a soft landing. But there is another difficulty in this case now. These two people were convicted. The judge made an order that they should forfeit their assets. Even if Nigeria give PD and I 9.6 billion or whatever is the amount and say, okay, this is the amount. But we still have a court order that say you must forfeit all your assets to us. In which case, we can say, look, give me the money back, or we will not pay.
The forfeiture of assets, is it not conditional to the fact that if you don't pay $9.6 billion, then you will forfeit assets worth the 9.6 billion?
I take your point, but take my point.
Right.
If the judge made an order that all your assets should be forfeited to me, and you are now saying you owe me 9.6, and I have an order in my favor that you should forfeit all your assets. So you want me to give you the 9.6 so that you can disappear, and then what is the essence of the order in my favor? I can turn around and say, look, I have a court order against you. I agree, I owe you 9.6 billion, but that will be part of your asset. I'm forfeiting that because there's a forfeiture order.
All right. Now, the representatives of P&ID Virgin Islands and P&ID Nigeria Limited pleaded guilty to the 11 count charges against them.
Yeah, the Nigeria
what impact is that having on the Nigerian case going to the UK?
No. That is the most significant impact. Okay. Because, you see, all these, initially the Attorney General was saying we have EFCC reports, we have this. Those are, there'll be an issue about that because those evidence have not been tested. But now what they've done is to make sure these people who are arraigned before the court, they had the benefit of legal advice and they pleaded guilty. It's not that the court convicted them, in which case the other side will argue that, look, they still have a right to appeal, it's not finished. They pleaded guilty. So what you need is that you get the certificate of conviction that will go before the court. But on the 26th, it may well be this will be all part of the argument, and those courts might say, look, they might turn around and say that this matter should be relisted for argument. Or on the other hand, they might just say, look, there are a lot of issues here.
Oh, all right. I would have loved to look at a scenario where maybe going forward, there is another statement that we pleaded guilty under duress or something. I wonder if that scenario plays out.
No. That doesn't even, did they put the gun on their head and say you should plead? Don't forget they had the benefit of legal advice. Right. And that is what is crucial. Right. So you can't say they put me under pressure, you pleaded guilty. And remember what happened in Bori's case.
Yeah,
he pleaded guilty on his own. And that's
all right. Olufemi Aina, UK solicitor, thank you so much for coming on the program.
Thanks,
thank you. Right.
Now, the Attorney General of the Federation is saying Nigeria now has a judicial proof of fraud and corruption as a foundation of the relationship, hence cannot stand judicial enforceability. How so?
Well,
break this down.
I agree with him to an extent, but the ultimate decision is with the court. But what Nigeria has done is to try and lay a foundation that, look, this is a contract characterized by a lot of underhand dealings. And once there's element of fraud, that makes the contracts to be void and what have you.
So it's not cogent enough?
Well, it is. It is cogent to an extent. But what I'm saying is that, look, fraud vitiates everything. Once there's element of fraud in a contract, then it makes it difficult to move ahead or enforce. And that is what the Attorney General is getting at. But what they still need to do at the end of the day is to be able to put the evidence before the court so that they can have this judgment against them set aside.
They already have an evidence, so to speak.
Yes.
So would it be difficult to use that? Because you're saying that they should be able to put that before the court.
Yes, it's not that totally difficult because what the court will accept is what is called certificate of conviction. Because even if you go with the EFCC report and what have you, that's not. But it's not limited to that because money has exchanged hand. You know, part of his, if you listen to his comments, he said that we have evidence that some of these government officials were paid $1,000 to $50,000 here and there. So you need to come with that bank statement. You need to get the security agencies.
Wouldn't that be quite challenging?
What's challenging about that? This is a civil proceeding. It's not a criminal proceeding, the reasons of it. It's a civil proceedings, and what you need to do, get a witness statement from the investigator, get the certificate of conviction, get all the available evidence and put it before the court that, look, whatever the case, we know this contract should not have happened if not because money has exchanged hand. And that can make things difficult for PD and I. And if you look at them, you know, they've been going on the rooftop since saying the conviction was a sham.
Yes.
The Attorney General is doing this, is doing that, because the case is becoming difficult. And there is one important point which I would just like to mention quickly, is that, you know, this case is funded. Because in the United Kingdom, when you have a case like this, you can get people you call legal funders. They are like people you call venture capitalists. This is the case. It's a very big case. You put everything to them, and they can say, look, we are going to fund everything about the case. Maybe when you win, we will take a court and what have you. And now, as you go along, you need to you update them regularly.
Yes, absolutely.
And now, if Nigeria can boost a cast iron case and get the funders to withdraw the funding, that will make things difficult for PD and I. And that is the strategy the Attorney General is trying to apply here. That, look, once
so we are on track on building a cast iron case.
I must say this to you, at least we need to be fair and objective. We are on the right track now, but we need that momentum. It has to continue, and it's not limited to that. You need to get as much evidence as you can get to make sure that you convince the court that, look, had they been, this information was before the arbitral tribunal, they wouldn't have even ruled.
But one thing that is very important to Nigerians is how we can prevent a reoccurrence of issues like this.
Oh yes, I'm very grateful you asked me that question. You see, there are a lot of lessons from here. And I must say, it's a very simple issue. It's just that when people lose focus, then that's when it becomes a problem. Now, when you appoint people, either as a minister, either as a director, you need to make sure they have a contract. Ministers are now in position the last 3 days. They are political appointees, but their contract of service is with the federal government of Nigeria or Nigerian people. So what you need to do is this. Even in your organization here, you have people you call director. They have what they call director service contract. And you need to put something called an indemnity clause, even if including ministers, that, look, this indemnity clause will provide that if after your tenure of office, and we now discover that, one, you engage in bribe or whatever. 2, you fail to follow a proper procedure. 3, you did not carry the Federal Executive Council along in your decision-making, whatever. You will indemnify the federal government of Nigeria, in which case you can go for them or for their asset. And even if you don't put it in the contract, at common law, if you discover that they fail to act in good faith, because they've been taking bribe and what have you and put Nigeria in a mess, you can still go after their asset. And if they are dead, you go after their estate. And that's what
but then do you think that things like this can actually work?
And it will work because, you know, the Attorney General, I think he has sent a letter to all the ministries that he wants to have a list of all the contracts and whatever with any foreign organization.
Okay. Yeah. UK Solicitor Olufemi Aina, thank you for your time.
Yes, thank you.